your theft. You have specially made tools that are used in the commission of your crime. You can't, a judge cannot be lenient with you. You cost everybody. You are a one-person crime wave. It's thefts that cost everybody more money at merchandise stores.
Imagine standing before a judge and hearing your criminal history described as one of the most prolific ever to enter that courtroom. That is exactly where Ms. Tiffany Marshall finds herself in this extraordinary sentencing hearing. According to the exchange you are about to hear, the court is dealing with a record numbering in the dozens, described at different points as 96 infractions and as many as 97 convictions or incidents. But the number is only the beginning. The judge says this pattern stretches back approximately 30 years and involves repeated theft-related offenses, including the alleged use of specially made tools during the commission of the crime. Now, the defense is asking the court to consider Marshall's serious health problems, her family responsibilities, and a sentence at the low end, or even reduced punishment under what counsel calls 12.44. But the judge sees a much bigger issue. After decades of court appearances, prior punishment, and repeated opportunities to change, should illness and personal hardship still justify leniency? Watch how quickly this hearing shifts from a request for mercy into a devastating assessment of Marshall's entire criminal history. And when the sentence finally comes down, her desperate request for a little more time produces one of the judge's sharpest responses. Would you still consider probation in a case like this, or has the opportunity for leniency already passed?
That's a problem. It's your criminal history. 96. That's one of the most I've done this for a long time. Thousands of cases. You are one of the most prolific criminals that have set foot in this room. And I guess you have used similar kinds of sad stories to others to try to minimize your responsibility. But this is nothing to be proud of, and it's not anything that this court can really sympathize with you. People come in here, everyone comes in here. Maybe one or two out of the thousands have been more prolific in their criminal actions, quantity of crimes more than you. But all of those thousands of people that come before me could say, Miss Tiffany Marshall, she had 97 convictions, and you let her kind of sashay out of here. And I'd like the Tiffany Marshall rule, please, because aren't you supposed to be fair, Judge? Yeah, I am. I should be fair. And everybody is to be judged based upon their criminal history and character. And this is not, it was very poor character. And your criminal history is most prolific. This court is not going to change the rule of law, which states people are responsible for their bad acts, their criminal acts. They must be held responsible.
This is the central conflict of the hearing. The judge is emphasizing accountability and equal application of the law, while the defense is about to focus on mitigation, the personal circumstances that might justify a less severe sentence. Counsel questions whether every theft by check citation resulted in a conviction and then asks for probation, 6 months at the low end, or possible treatment under Section 12.44. In Texas, Section 12.44 can allow certain state jail felony defendants to receive misdemeanor-level punishment, depending on the circumstances and the court's legal authority. But it does not erase the underlying conduct, nor does it guarantee leniency. It is a request the judge may reject. Here, the defense's strongest argument is Marshall's poor health and the burden incarceration could place on both the jail system and taxpayers. The judge, however, appears concerned that accepting that argument too broadly would effectively create a different standard for defendants with serious medical conditions. So, what should matter more here? The defendant's current health or the enormous criminal history the court says she accumulated over 3 decades.
Anything else?
Well, I don't know that all of the theft by check citations were convictions. I know that she said she handled most of her things by paying her checks off. But the other thing is, I would ask the court that if the court is not willing to allow her to be on probation, and even though she got a year the last time she had a state jail felony, we would ask that you consider something on the low end, 6 months, or even a 1244. Even in light of her other problems that just we would have to, as the taxpayers, have to deal with because she's so ill. So I would ask the court, if you're going to send her to jail, that you consider something on the low end.
Anything else? If not, on that argument, truly, then people who are seriously ill have carte blanche to do pretty much anything they want, and everyone has some form of situation health-wise that they're dealing with. Even the most healthy people are not perfect. I so find you guilty. I'm following this agreement. You are hereby sentenced to confinement in the state jail for a term of 15 months.
The judge has rejected probation, rejected the request for 6 months, and declined to reduce the punishment in the way the defense requested. That decision makes the court's position unmistakable. Marshall's medical condition may be relevant, but in this judge's view, it does not outweigh the repeated criminal conduct described during this hearing. Notice that the judge does not immediately move on after announcing the sentence. Instead, he explains why leniency is no longer appropriate. He points to the scale of the criminal history, the repeated thefts, and the allegation that specialized tools were used to facilitate the offense. He also broadens the impact beyond the immediate victim, arguing that retail theft creates losses that can eventually be passed on to ordinary customers through higher prices. This is no longer being treated as one isolated mistake. The judge sees an established lifestyle and a continuing pattern that earlier court interventions failed to stop. Do you believe 15 months is proportional, or should decades of repeated offenses have resulted in an even harsher sentence?
You will be given credit for all time that you have served in accordance with this. Your lifestyle, see, Ms. Marshall, you have a lifestyle that you feel shocked that committing crimes should hold you accountable. You have 96 infractions of law, 96, and you are committing these crimes with special tools for getting away with attempting to commit your theft. You have specially made tools that are used in the commission of your crime. You can't, a judge cannot be lenient with you. You cost everybody. You are a one-person crime wave. It's thefts that cost everybody more money at merchandise stores because their theft, the loss is so high. We have to pay for your criminal acts. But after 96 times you have had to go deal with crimes in various courts, from felony courts to misdemeanor to Class C misdemeanor courts, you would have gotten the message, and you never have. You just are a career criminal. That's you're the very essence of a career criminal. And I wish you wouldn't do that. Thou shalt not steal. You've heard of that one. And it's not only written in moral issues, but it's right there in the law. There's a full section or 2 or 3 in the penal code which deal with dishonest acts, and that's where you are. I'm sorry. I just wish you'd have changed your ways. But like I said, you've been doing this for 30 years. 30 years. Okay.
Judge, can I get some time to get my stuff in order and go to my doctor to get my vaccine?
No, ma'am, not under this situation. The jail is going to be able, those people in the jail take care of people who have medical issues. I trust them. They are good at their job. I'm going to give you a chance during the Christmas season to go out and steal more stuff. I don't think so. Well, you've always done that. You've done that for 30 years, 97 times now.
Just take it to traffic violations. So please. I got my grandkids living.
Ma'am, my God. Ma'am, you didn't think of all of that when you made a choice to steal? You didn't think of what you had to lose? And the people who rely on you or respect you or look up to you? I've got children. I've got grandchildren. They help me make the right choices, and it's not all that hard to think about them first. And you don't. You just thought about stealing for your needs. I'm sorry. I don't mean to. I hate being the Grinch here, but
it's like all them times it's like tickets and
ma'am, they were all crimes that you were found guilty of. They were all crimes. All of them were crimes. That is all. And make sure that you inform the jail about your health needs so that they can get the proper medication for you.
This hearing ends with the court sentencing Tiffany Marshall to 15 months in state jail, with credit for eligible time already served. The defense sought probation or a significantly lower punishment, relying heavily on Marshall's medical problems and personal circumstances. The judge rejected those requests because of what he described as an extraordinary and persistent criminal history, repeated theft-related conduct, and approximately 30 years of failed opportunities to change. When Marshall asked for additional time to organize her affairs, see her doctor, and help with family responsibilities, the judge refused. His reasoning was direct. Those responsibilities existed before the offense, and he believed they should have influenced her decisions at that time. Still, the court did acknowledge her medical needs by directing her to inform jail officials so she could receive appropriate medication and care. The broader takeaway is that mitigation can influence sentencing, but it does not automatically override accountability, especially when the court sees a long-term pattern rather than an isolated lapse in judgment. Was the judge appropriately firm, or did Marshall's health and family situation deserve more consideration? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.